Good morning, everyone. Thank you very much for joining us today on Facebook Live. We're here today to discuss the introduction for two pieces of legislation that are designed to create a fairer criminal justice system in our state of California. At this point, we're all too familiar about the devastating impact of sexual assaults and rape that continue on in our communities, specifically women in particular. Some of these cases, such as the Stanford rape case, received an incredible amount of attention, but oftentimes that is the exception and not the rule. Sexual attacks and rape cases are frequently not discussed in public unless they involve a celebrity. Or in the Stanford rape case situation, they often include an incredibly brave and eloquent survivor who exposes how privilege and power have created two systems of justice, one for the wealthy and one for the rest of us. Today, we are here to discuss the imbalance of California in our criminal justice system, which is that of spousal rape. It may sound counterintuitive, but California actually treats rape of a spouse differently than other sexual assaults. This should absolutely not be the case. Rape is rape. For this reason, Assemblymember Cristina Garcia, Senator Dave Cortesi, and myself are here today to talk about two pieces of legislation, Assembly Bill 812 and Senate Bill 530. We just introduced these bills to address the oversight in our California criminal justice system. We are also joined today by Stanford law professor Michelle Dapper, as well as district attorneys from San Francisco and Santa Clara County, all of whom are experts in the issues of sexual violence and prosecuting these horrific cases. Thank you, everyone, for joining us. I'll now turn over the conversation to my colleague, Assemblywoman Cristina Garcia, who is also the chair of the California Women's Legislative Caucus. Cristina.
Thank you, Assemblymember Law. I appreciate it, and thank you to everyone that's here today. Good morning, everyone. In California, the concept that no means no and rape is widely accepted as social value. Still, California is one of only 11 states that distinguishes between rape and spousal rape. That means there are 39 other states that treat all rape the same. If an individual is raped by a stranger or even their partner, which they've had long years relationship, the act is traumatic and carried for a lifetime and considered rape by the state of California. However, the exact same act by a spouse is treated less punitively, including shorter sentences, and they do not have to register as a sex offender. Spouses that experience rape suffer from long-lasting physical and psychological effects from their experiences. A handful of studies have found post-traumatic stress disorder, fear, anxiety, depression, and sexual dysfunctions to be consequences of marital rape. A marriage license doesn't make the consequences of rape any less severe. AB 812 and SB 530 seek to accomplish the same goal, to eliminate the spousal rape statute because rape is rape, regardless of marital status or not. This bill would simply modernize an antiquated law and modernize the statutes to better reflect California's values. When spousal rape is not treated as seriously as other forms of rape, it invalidates the victim's traumatic experiences and continues to promote rape culture. Moreover, a rapist should not be shielded from punishment simply because the rapist is married to the victim. In California, the concept that no means no and rape is widely accepted social value, and our laws must match that. It is for these reasons that we introduce this legislation and hope that this bill makes it all the way to the governor's desk. Thank you.
Thank you very much, Assemblywoman Garcia. Next up, we have Senator Dave Cortesi.
Thank you. Thank you very much, Assemblymember Lowe. Can everyone hear me okay?
Yes.
Thank you. Well, as Assemblymember Garcia said, time has long since passed for California to declare that rape is rape. And these bills will provide parity by abolishing the distinction between spousal and non-spousal rape in California. The introduction of the two bills in both houses of the legislature, I think, shows our unified commitment to ending this distinction once and for all. Until 1975, every state in our country exempted marital rape from ordinary rape law. It remains clear that vestiges of this antiquated marital rape exemption still permeate California law even to this day. While the legal distinction of what constitutes spousal and non-spousal rape are now the same, the penalties in our state for spousal rape continue to be less severe, and I know that's been pointed out. These disparities also extend to plea bargains. A defendant accused in the non-spousal rape of an unconscious person, for example, cannot plea bargain. But if a defendant is married to the unconscious victim of the rape, they are currently able to plea bargain. There's no reason for that distinction. California Penal Code defines the crime of rape in two separate code sections. Section 261 provides the circumstances that constitute non-spousal rape, and Section 262 provides the circumstances for spousal rape. Our bills would repeal Section 262 and expand the definition of rape in Section 261 to include all rape. Under SB 530 and AB 812, California will require a person convicted of spousal rape to register as a sex offender, just as currently required of a person convicted of non-spousal rape, and also ensure that plea bargains are treated the same for both crimes. Attempts to level these heinous crimes in the past have been met with progress and failure alike. Just as recently as 2019, before SB 459, authored by Senator Galgiani, became law, a defendant who raped a spouse while the victim was unconscious or under controlled substance would have received a lesser sentence enhancement. By finally and decisively putting an end to the archaic spousal rape exception, we're not only leveling the law, we're preventing marital rape and promoting safety and respect for all. Thank you very much.
Thank you very much, Senator Cortesi. Next up, I'd like to invite Michelle Dapper.
Thank you so much, Assemblymember Lowe. And thank you to our distinguished elected leaders who have joined together today to end the spousal rape double standard in California. Historically, men could rape their wives with impunity. This double standard dates back to the 17th century English common law. This did not begin to change until very recently. In the United States, the first conviction of a husband for the rape of his wife was not until 1979. Although all states now outlaw spousal rape in some form, California remains one of a small handful of states that continue to distinguish spousal rape from non-spousal rape and treat it as a far less serious crime. I think that California voters will be absolutely shocked when they learn that our progressive state of California continues to maintain this antiquated distinction that is based on the idea that men have a property right of sexual access to the bodies of their wives. The spousal rape double standard sends a terrible message to victims of sexual violence perpetrated by spouses and to society in general, that spousal rape is less serious and less harmful to victims than rape by a non-spouse. This in turn may make victims less likely to report these crimes or to seek help when they need it. Meanwhile, there are disturbing indications that spousal rape is increasing, along with other intimate partner violence during COVID-19. A recent report by the San Jose Police Department stated that although rapes show an overall decline of 9.4% over the last year, domestic and spousal rapes have doubled. We must take action now, and we ask the legislature to pass this bill quickly and that the governor would please sign it into law without delay. This bill will ensure that in California, all rape is treated equally under the law, regardless of the relationship between the victim and the perpetrator. I'm pleased today to be part of a broad coalition of individuals and organizations, including advocates for criminal justice reform and women's rights organizations, including the Feminist Majority, the National Organization for Women, Equality Now, and the Women's Equal Justice Project. This bill is also supported by numerous elected leaders from California, including those here today, and many others, such as Congressman Ro Khanna. California's spousal rape law is a slap in the face to all women and all sexual assault survivors, and it must go. Rape is rape, period. Now, as California chapter president, Coleeka Siegel is here today to say a few words of support about this bill. And we are very honored to have the support of the National Organization for Women in this effort, and we'll now hear from President Siegel.
Thank you so much, Professor Dapper, and thank you for allowing me to join you today for this critically important issue. My name is Coleeka Siegel, and I'm the first African-American president of the California National Organization for Women. And since our founding in 1975, ending violence against women has been one of our core issues, and that means all women. And we rise today in fight and pursuit because we would stand for justice for women, whether they were married or not. We would stand for their safety and for their protection of the married woman just as well as the single one, as this crime and its impact is the same. The biggest problem is the antiquated thinking surrounding sexual violence, our collective ignorance on how we define and view victims, and our inability to call a spade a spade. Rape is romanticized in the public consciousness as a stranger jumping out of the bushes from the shadows. And we know that more often than not, the perpetrator is known to the survivor. My message today is very simple, that rape is rape. If you're a college student, rape is rape if you're a woman of color, rape is rape if you're a trans woman, and rape is rape whether you're married or not. We at California Now support the whole woman in pursuit of justice for these unspeakable crimes, and those found guilty should receive parity in punishment as if the rape was committed against someone who is not a spouse, including registering as a sex offender. And in closing, during this global pandemic, we're often, the message out there is often that we are safer at home.
Oops, it appears that we may have lost the audio.
Stand with survivors as we unequivocally call for an end to the situational support of women. What do you mean by that, Coleeka? The situational support of women. The idea that you have to be a certain type of victim, often having to be a certain color, often having to be a certain socioeconomic background, a certain sexual orientation, and now a certain marital status. This situational support must end, and I will turn it back over to Assemblymember Lowe.
Coleeka, thank you very much for your moving words, especially as we recognize the month of March as Women's History Month. And it just goes to show about the solidarity that we have collectively together. So thank you very much for your compelling words. Next up, I'd like to introduce the District Attorney for the County of Santa Clara, who is well known for his surpassing legal acumen and his unassailable integrity. That is my very own District Attorney, Jeff Rosen.
Thank you so much, Assembly members. So nice to join all of you today in this important endeavor. You know, the more things change, the more they stay the same. So many changes as we undergo a seismic shift in exploring what criminal justice means. We are embracing different ways to hold someone accountable without saddling them with crushing lifelong consequences. These include sentencing alternatives to incarceration for nonviolent crimes, getting rid of cash bail, considering immigration consequences, and supporting record clearances when appropriate. But what has not changed and will never change is how we view rape. Rape is a violent crime that is both physically and psychologically harmful to the victim. A marriage license and a wedding ring do not make rape a less serious offense. And the existence of a marriage license and wedding ring should not make a rapist less culpable or less deserving of serious consequences. More and more people today live together and or have children together without being legally married. This fact highlights how antiquated it is to distinguish between married and unmarried when holding rapists accountable. My sexual assault prosecutors go into court every day tasked with the responsibility of proving each and every element of the crimes charged. When that crime is rape, the prosecutor must prove that the victim is not the spouse of the perpetrator. When the crime is spousal rape, the prosecutor must prove that the victim is the spouse of the perpetrator. My reaction to these arcane elements, who cares? Who cares? It should not matter. It does not matter because rape is rape. When a non-spouse is convicted of rape, we can be assured that the offender is going to prison and will have to register as a sex offender. A spousal rapist, however, in most cases is not automatically going to prison. The law allows a spousal rapist to get probation, and if he gets probation, he doesn't even have to register as a sex offender. As district attorney, I must be diligent in ensuring the fair application of laws to criminal offenders. To do so, the laws themselves must be fair. It is inherently unfair to allow marital status to be an escape hatch for accountability for rape. These distinctions and unequal punishments may have made sense at the time the spousal rape law was enacted, but it makes absolutely no sense today. It was born in a time when people believed that wives must obey and that a husband had a right to have non-consensual sex with his wife. This outdated and antiquated law must go. Rape is rape. Join me, join us in this important criminal justice reform. Thank you.
Thank you very much, DA Rosen. We're also honored with our last speaker and appreciate his support. That's San Francisco District Attorney Cesar Budi.
Thank you very much, Assembly Member Lowe. Thank you, Assembly Member Garcia and State Senator Cortesi for your leadership, for sponsoring this important and long overdue legal reform that will help keep our communities, especially vulnerable members of our communities, safer, that will give law enforcement the tools we need to enforce laws equally. Look, the scale of this problem is massive. 1 in 5 women in this country will be the victim of sexual assault at some point in their lifetime. 1 in 5. Now, regardless of who commits these heinous, violent crimes, whether it's a stranger, whether it's someone known to the victim, or whether it's someone in a legal relationship with the victim, it is a violent, heinous crime. These crimes involving sexual assault and violence, have unique impacts on survivors, often layered with extensive, long-lasting trauma responses, including shame, doubt, and many other lingering reactions. And the bottom line is, it does not matter what the relationship is. No means no, rape is rape, and law enforcement needs the tools to hold people who commit these devastating crimes accountable, to encourage survivors, no matter who they are, to come forward and seek justice. Thank you for your leadership. I'm proud to stand in support of this important reform. Thank you.
Thank you very much. That concludes the remarks from those in support and also sponsors. And just to reaffirm that as chair of the California LGBT Legislative Caucus, myself, along with chair of the California Legislative Women's Caucus, Assemblymember Garcia, recognizing the impact on our collective communities. Now that we've heard from everyone, I'd like to open up the conversation to individuals who wish to ask any questions of any of the participants and panelists. Feel free to type into the chat box should you have a question directly to any of the panelists or to any of the questions at large. Again, we are so proud to stand alongside these leaders in addressing the shortcomings in our criminal justice system. Finally, for those watching at home, thank you very much for giving us an opportunity to discuss this issue. Please be sure, please be sure to reach out to your state assembly member and or your state senator and urge their support of these respective bills to ensure that we have a safer and more just society for everyone. Again, now we'll get into any questions or comments. Feel free to type that in the chat box. And if not, then we'll let our participants get on their merry way. So again, feel free to ask any questions in our chat box. And I see we're allowing some time for any questions right now.
There's a question from Kathy Novak, KCBS.
Please, Kathy.
Let me see if I can get her here. Hold on. Oh, okay.
You have the questions in the Q&A. Maybe someone wants to read it.
Hi
for
there.
her.
I think I've been muted now. I was just hoping to ask the panelists, could you explain what has stood in the way of this kind of reform in California until now?
I'll defer to Assemblymember Garcia, who's been working this issue a little bit longer than I have. I'm a freshman senator here, and I know there's been some history of concerns which I think are far outweighed by the injury and the trauma that's done, and by not doing anything here. But Assemblymember, I'm happy to defer to you.
Thank you. And let's have about we tag team this. I'll start it, but I think maybe Michelle or Dee or Evan might want to supplement that. I mean, I think our speakers spoke about the outdated notion that a marriage license gives you ownership to your spouse's body. And with that, you know, we have these more lenient policies that make no sense to me. It just, when I learned about this, I was like, really? Like, this makes no sense. And so I think that's been a driving force. I think as we talk about restorative justice along the way, you know, I think that there's been an excuse to use that, in this case also to continue to make excuses that gives people a permission because you have a marriage license out there and wanting to treat something differently and to start misunderstanding that the trauma is the same no matter what out there. And so I think that that's a little bit of what's been happening. And I think sometimes it's just lack of knowledge. People, I think, are not aware. I was not aware that this was the case. I always assumed that we treated it the same. When we did the work on the Brock-Turner legislation that Mr. Lowe and I both led, I just assumed that this was the case and this was taken care of. And so I was just a little dumbfounded when I found out that we still had this in statute.
I agree with what Assemblymember Garcia has said. I think that the primary impediment to this change is that people are unaware of it. As I said in my prepared remarks, I believe that if California voters were aware that our progressive state, which cares so deeply about civil rights for all people, I think if voters in our progressive state were aware that we had this antiquated law, I think that support would be uniform to eliminate it. And I think we're going to see, I hope, a speedy passage and a speedy signature by the governor. This is really just righting a historical wrong.
And to encapsulate some of an additional question, this came from Robert Salonga from the San Jose Mercury News. What has kept this reform from being instituted sooner? I think some of you answered some of those questions, but then we'll get into the second or the third question, I should say, from Bay City News. How prevalent is spousal rape, and what percentage of them are rapes? And so perhaps I'll put this to District Attorney Jeff Rosen.
Let me answer that. First point to understand, to give context to this, is that rape is tremendously underreported. Sexual assaults of all kinds are severely underreported. Domestic violence is severely underreported. So when you combine sexual assault and domestic violence, which is what a spousal rape is, they're very, very much underreported. What I can, and the reason we know that is from all kinds of studies of victims and offenders. We know these crimes are way underreported. But what I can say in terms of reported crimes, reported rapes, slightly less than 10% of reported rape cases are spousal rape cases. So it's a pretty significant number of the rape cases that we have in our state. And when you recognize how underreported it is, you realize that it's a much bigger number. I think part of the impetus behind this bill is to try to encourage women to come forward and report, and not to have this kind of double standard between married and unmarried victims.
And I'll just echo what DA Rosen said. Underreporting is a critical issue in all forms of sexual violence. It's one of the categories of crime that is the most underreported. And this reform is a critical part of empowering and encouraging survivors of sexual assault to come forward, to share their story, and to help bring justice and closure and prevent these kinds of acts from recurring in the future.
Budi, perhaps Shaylee, we could keep this conversation on you and DA Rosen to a follow-up question from Robert Salonga. For the prosecutors in practical application in court, has there been any latitude to seek equivalent penalties for offenders in spite of this penal code distinction, or have you been handcuffed by this?
Well, what I would say is we can ask for a sentence that is appropriate, which in the case of rape in my office is going to be prison. We can ask, but the law does not require it as it does if the participants are not married. So we ask, but often that's not the sentence that we get because the judge has an option to give probation and not have sexual and not have the person sexually register as a sex offender. So the advantage of this law is that it would level the playing field and the punishment would be the same. And a judge would still have discretion as to whether it's 3, 6, or 8 years in prison, but that discretion would be a little more limited and not allow for probation in a case of spousal rape.
I'll just echo Jeff, DA Rosen's comments as well.
Great, thank you very much. Another question, perhaps Coleeka and Michelle Dapper can also answer this question. Do you anticipate any opposition to these bills? Who would be opposed?
Coleeka, would you like to speak to that?
We always expect opposition. Contrary to some of the things already said on this wonderful panel, California is not as progressive as we claim to be on certain issues, which is why it has persisted this way for so long. So if you're looking for specific groups, I don't know just yet, but we will stand in opposition and do what we do to raise the issue. We will be calling for our body to call their legislators and to raise as much hell as possible about people who oppose this. Thank you so much.
I would just add, thank you, Coleeka. I would just add to that if you look at the many, many people here who are uniting behind this bill and the number of women's organizations and elected leaders and community leaders, I am hoping that there will not be opposition to this bill. This is a common sense reform that has attracted people from across the spectrum of organizations and reformers. I really think that this is a very simple matter of equity. There is no valid state interest in treating rape differently based on the legal status of the relationship between the victim and offender. There simply is no valid state interest served by that. And in fact, there is a valid state interest served by treating them equally. So I'm hopeful that there will be no opposition and this will speed through the legislature and be signed by Governor Newsom.
Thank you very much for that. As you heard it very clearly, there should be no opposition. This is a common sense piece of legislation, and we're so fortunate to have a wide variety of advocates in support of this as well. I don't see any additional questions or comments. Any final closing thoughts from any panelists or any members on here? Okay, seeing none, we know that we'll make ourselves readily available. Please, again, for those who are watching, please contact your state legislator and ask them to support this common sense legislation so that we can ensure that rape is prosecuted as rape. So thank you very much for joining us, everyone. We'll see you soon. Thanks again.